Welcome back to Immigration News Today. If you or someone you love has been waiting for a family-based immigrant visa, the February 2026 Visa Bulletin just dropped, and there are some important updates you need to know about right now. Whether you're waiting in the F2A category as the spouse or child of a green card holder, or you're in F3 or F4 waiting for your brother, sister, or married child to join you here in the United States, understanding this bulletin and what it means for your priority date could be the difference between missing your opportunity and finally moving forward with your case. Today, we're breaking down the February 2026 Family Visa Bulletin in clear, practical terms, explaining what's happening with F2A, F3, and F4 priority dates, what these changes mean for you, and exactly what steps you should be taking right now to protect your case and be ready when your number is called. So if you've been checking your priority date every month, if you're anxious about when your turn will come, or if you're just trying to understand how this whole system works, stay with me because by the end of this video, you'll know exactly where you stand and what to do next. Let me start by giving you the context you need to understand what's actually happening. The Visa Bulletin is published every month by the U.S. Department of State, and it tells us which priority dates are currently being processed for different categories of family-based and employment-based immigrant visas. Your priority date is essentially your place in line. It's the date that USCIS received your qualifying petition, usually your Form I-130, and it determines when you become eligible to move forward with your immigrant visa application or adjustment of status. The system exists because there are annual limits on how many immigrant visas can be issued in each category and for each country, and because demand often exceeds supply, people end up waiting, sometimes for many years. The Visa Bulletin has two charts that matter: Chart A, which is called the final action date, and Chart B, which is the dates for filing chart. Chart A tells you when a visa number is actually available for final processing, meaning you can complete your interview or adjustment. Chart B tells you when you can file your adjustment of status application if USCIS decides to accept filings based on that chart, which they announce separately each month. For family-based cases, USCIS has been using Chart A for most of the past year, so that's the one we'll focus on primarily. But I'll touch on Chart B as well because it's important to monitor both. Now let's talk about what we're seeing in the February 2026 Bulletin, as of the date this video is being prepared on February 9th, 2026. For the F2A category, which covers spouses and unmarried children under 21 of lawful permanent residence, there's been some movement, but it's modest, and it varies by country. For most countries, what the State Department calls all chargeability areas except those listed, the priority date on Chart A has moved forward to June 1st, 2022. That's a progression of about 3 weeks from the January Bulletin, which had shown May 8th, 2022. Now, 3 weeks might not sound like much, especially if you've been waiting for years, but any forward movement is a positive sign that visas are being processed and cases are advancing. For Mexico, the F2A priority date is currently at November 15, 2021, which represents a slightly smaller advance of around 2 weeks. The Philippines is seeing similar movement, and China and India are also progressing in the F2A category. If your priority date is earlier than the date listed for your country of chargeability, that means you're potentially current and eligible to take the next steps in your process. If your date is after the cutoff, you'll need to keep waiting and checking each month's bulletin. Moving to the F3 category, this covers married sons and daughters of U.S. citizens, and this is historically one of the slowest moving categories because of high demand and relatively low annual visa allocations. In the February 2026 Bulletin, for all chargeability areas except those specifically listed, the F3 priority date has advanced to October 15, 2009. Yes, you heard that correctly. We're talking about cases filed back in 2009, which underscores just how long the wait can be in this category. That's a movement of about 2 weeks compared to January's date of October 1st, 2009. For Mexico, the F3 date is even further back, currently at August 22, 2002, moving forward by roughly 2 weeks as well. The Philippines is at July 8, 2004, also showing incremental progress. If you're an F3 and your priority date falls before these cutoffs, you should be preparing for the next stage of your case. If you're still years away, I know this can feel discouraging, but understanding where you are in the process and staying informed is the best way to be ready when your time comes. The F4 category, which is for brothers and sisters of US citizens, is similarly slow-moving. For all chargeability areas in February 2026, the priority date is at September 1, 2007, an advance of about 3 weeks from the January Bulletin's date of August 8, 2007. Mexico's F4 date is at November 1, 2001. The Philippines is at June 1, 2003, and these dates reflect small but steady forward movement. The F4 category often sees the longest wait times of all family preference categories, sometimes stretching well over a decade, because the number of available visas is limited and demand is high, particularly from countries with large diaspora populations in the United States. So what does all this movement mean for you personally? First, if your priority date is now current or very close to current, you need to be proactive. If you're applying for an immigrant visa abroad, the National Visa Center will typically send you notification and instructions to begin submitting your documents and fees, and eventually schedule your consular interview. If you're in the United States and eligible to file for adjustment of status, you'll want to make sure you have all your paperwork in order and that you're monitoring USCIS announcements about whether they're accepting applications based on Chart A or Chart B for the current month. As of now, for February 2026, USCIS has indicated that family-based adjustment of status applicants should use the final action dates in Chart A. So if your priority date is current under Chart A and you're otherwise eligible, you can file your Form I-485. That's a critical detail, so double-check the USCIS website or consult with an immigration attorney to confirm the current policy before you submit anything. Second, even if your priority date is not yet current, this is the time to get your documents together and make sure everything is up to date. Your passport should be valid, your police certificates if you're applying from abroad should be recent, and any supporting documents like birth certificates, marriage certificates, divorce decrees, and proof of the petitioner's status should be organized and accessible. One of the biggest delays people encounter is scrambling to gather documents at the last minute once their priority date becomes current, and that can cost you weeks or even months. If you're working with an attorney, now is the time to check in and make sure they have everything they need. If you're handling the case on your own, take the time to review the NVC or USCIS instructions carefully, and don't hesitate to reach out to official sources or qualified professionals if you have questions. Third, be aware that priority date movement is not always linear. Some months you might see the dates jump forward significantly. Other months they might move only a few days or even retrogress, meaning they go backward. This happens because of how visa numbers are allocated and used throughout the fiscal year. The State Department tries to ensure that all available visas in each category are used by the end of the fiscal year in September, but they also have to manage demand carefully to avoid running out of numbers too early. So while the February bulletin shows forward movement, there's no guarantee that March or April will show the same pace. That's why it's so important to check the bulletin every month when it's released, usually around the second week of the month, and to stay in close communication with your attorney or your case representative if you're going through the National Visa Center. Let me also address a question I get all the time. Why does my country have a different date than other countries? The answer lies in how the immigration system allocates visas by country of chargeability. No single country can receive more than 7% of the total family-based and employment-based immigrant visas in a given year. This per-country limit means that countries with very high demand, like Mexico, the Philippines, India, and China, often have much longer backlogs than countries with lower demand. Your country of chargeability is usually your country of birth, not your current citizenship, so even if you're now a citizen of another country, you're still typically charged to your country of birth for visa number purposes. There are some exceptions like cross-chargeability if your spouse was born in a different country, but those are case-specific, and you should discuss them with an immigration attorney if you think they might apply to you. Now, let's talk about what happens once your priority date becomes current. If you're outside the United States and processing through a U.S. consulate, the National Visa Center will contact you with instructions. You'll need to submit your DS-260 immigrant visa application if you haven't already, pay the required fees, and provide all the civil and financial documents they request. This includes things like police certificates, medical exam results, proof of financial support from your petitioner, and original civil documents. The medical exam has to be done by a physician approved by the consulate, and it's typically valid for 6 months, so don't do it too early. Once NVC has reviewed your documents and confirmed everything is in order, they'll schedule your visa interview at the U.S. consulate in your country or region. At the interview, a consular officer will review your case, ask you questions about your relationship to the petitioner, your background, and your plans in the United States, and they'll make a decision on whether to approve your visa. If approved, you'll receive your immigrant visa, and you'll typically have 6 months to enter the United States and complete the process to become a lawful permanent resident. If you're in the United States and eligible to adjust status, once your priority date is current under Chart A and USCIS is accepting filings based on Chart A, you can submit your Form I-485 along with all the supporting documents, fees, and medical exam. You'll eventually be scheduled for a biometrics appointment and then an interview at a USCIS field office. The interview is similar to the consular interview. The officer will review your application, verify your documents, and ask questions to determine your eligibility for a green card. If everything goes smoothly, you'll be approved and will receive your green card in the mail within a few weeks. One critical thing to keep in mind is that even if your priority date becomes current, you still have to meet all the other eligibility requirements for a green card. That means you can't have certain criminal convictions, you can't have immigration violations that make you inadmissible, you need to show you won't become a public charge, and you need to be admissible on health and security grounds. If you have any issues in your history, like prior unlawful presence, criminal arrests, misrepresentation on a prior application, or anything else that could affect your admissibility, you absolutely need to consult with an experienced immigration attorney before you proceed. Some issues can be waived, but waivers take time and require substantial evidence, so you want to address them early in the process. Let me also touch briefly on what's happening in the broader immigration policy environment as of early 2026. Immigration policy in the United States continues to be a subject of significant political debate, and there have been various proposals and executive actions over the past few years that could affect processing times, eligibility, and the availability of visas. While the Visa Bulletin itself is primarily a function of statutory limits and demand, policy changes at USCIS, the State Department, and other agencies can influence how quickly cases are processed, what documentation is required, and even whether certain categories or programs are prioritized or deprioritized. For example, there have been discussions in Congress about reforming the family-based immigration system, raising or eliminating per-country caps, and creating new pathways for certain groups. As of now, no major legislative changes have been enacted that would fundamentally alter the family preference system, but things can change, and they can change quickly. That's why I always recommend staying connected to reliable news sources and official government announcements, and if you're working with an attorney, make sure they're keeping you updated on any policy shifts that could affect your case. Here's what you should be doing right now, today, after watching this video. First, go to the U.S. Department of State's Visa Bulletin page and look up the February 2026 Bulletin yourself. Check both Chart A and Chart B for your category and your country of chargeability. Write down your priority date if you don't have it memorized already, and compare it to the dates in the bulletin. If you're current or very close, take immediate action to prepare your documents and reach out to the National Visa Center or your attorney. If you're not current yet, Note how much the dates have moved and set a reminder to check again when the March bulletin comes out. Second, make sure your contact information is up to date with USCIS and NVC. If you've moved, if your email has changed, if your phone number is different, update it immediately. Missing a notification because NVC couldn't reach you is a completely avoidable mistake that can set your case back significantly. Third, if you're the petitioner, meaning you filed the I-130 for your family member, make sure you're still meeting the requirements to sponsor them. That means you're still a lawful permanent resident or U.S. citizen, you're still able to provide the required financial support, and you haven't had any changes in your status that could affect the petition. If your status has changed, notify USCIS and consult with an attorney immediately. Fourth, educate yourself about the process ahead. USCIS and the State Department both have detailed guides on their websites explaining the immigrant visa process and the adjustment of status process. Read through them, familiarize yourself with the forms, the fees, and the timelines, and don't rely solely on secondhand information from friends or online forums. While community support is valuable, official guidance is what you should base your actions on. Fifth, if you haven't already, seriously consider consulting with a qualified immigration attorney, especially if your case has any complications. An attorney can review your specific situation, advise you on the best strategy, help you gather and organize your documents, and represent you at your interview if needed. Not every case requires an attorney, but many do, and the cost of getting it wrong can be years of additional waiting or even a denial that's hard to overcome. Let me also say this. I know how hard the waiting is. I've worked with families who have been separated for years, who have missed birthdays and weddings and graduations, who have watched their children grow up through video calls instead of in person. The U.S. family-based immigration system is slow, and it can feel arbitrary and unfair, especially when you see the dates move backward or stall for months at a time. But the system does work, slowly but surely. And every month, thousands of families are reunited through this process. Your patience and persistence matter, and staying informed and prepared is how you make sure that when your moment comes, you're ready to seize it. Before I wrap up, I want to remind you that everything I've shared with you today is based on the information available as of February 9th, 2026, and immigration policy can and does change. The visa bulletin dates I mentioned are accurate for February 2026, but by the time you're watching this, a new bulletin may have been released with different dates. Always verify the most current information on the official U.S. Department of State Visa Bulletin page, the USCIS website, and if you have questions specific to your case, consult with a qualified immigration attorney or accredited representative. Nothing in this video is legal advice, and it's not a substitute for personalized guidance from a licensed professional who can review your specific circumstances. Immigration law is complex, and every case is different. So while I hope this video has given you a clear overview and practical steps to take, your individual situation may require additional considerations that I can't address in a general video like this. If you found this breakdown of the February 2026 Visa Bulletin helpful, please take a moment to hit the like button and share this video with anyone you know who's waiting for a family-based visa. Sharing accurate, up-to-date information is one of the best ways we can support each other in navigating this complicated system. And if you haven't already, subscribe to Immigration News Today and turn on notifications so you don't miss our coverage of future visa bulletins, policy updates, and other immigration news that affects you and your family. We're here every week bringing you clear, reliable information to help you understand your options and take control of your immigration journey. Check the description below for links to official resources, including the State Department Visa Bulletin page, the USCIS website, and guidance on finding qualified immigration attorneys. Thank you so much for watching, and remember, you're not alone in this process. Thousands of people are waiting just like you, and every month brings new opportunities for progress. Stay informed, stay prepared, and stay hopeful. We'll be here with you every step of the way. Until next time, take care and keep moving forward.